November 4th, 2009. Benton County, Indiana. The morning the bank took the farm, the temperature was 24 degrees, and Leland Croft was already in the equipment shed before daylight. He had 160 acres of harvested cornfields sitting under frost. He had a John Deere 4230 with a cracked radiator hose he'd been meaning to replace since September. He'd been meaning to do a lot of things. The foreclosure notice had come in August. Meridian Federal Bank. 3 pages of legal language and a date circled in red. November 4th, 2009. Leland had read it twice on the kitchen porch and folded it back into the envelope. He was 59 years old, had farmed this same land in Benton County since he was 22. His father had farmed it before him. His grandfather had bought it in April of 1947 from a private landholding company out of Chicago. $18,400 for 160 acres and a 2-story farmhouse with a limestone foundation that was already 40 years old. The debt was $214,000. Borrowed in 2006 against a futures contract for corn that had looked like a reasonable bet at the time. Corn hit $7.80 a bushel by the summer of 2008 and then dropped to $3.90 by October. The contract settled at a loss. Leland had refinanced twice trying to recover ground. The third refinancing was the one he couldn't cover. 2 men in a dark blue Buick arrived at 8:40 that morning. They parked at the end of the gravel drive, didn't get out immediately. One of them wrote something in a folder. The other took a photograph of the farmhouse. Leland watched from the shed. He had grease on his hands from the radiator hose. He wiped them on a rag that had been white once. They served the documents at the door at 9:03. Leland signed where they indicated, said nothing. They drove back down the gravel drive and turned onto County Road 100 North. The crunch of gravel faded, and then there was nothing. He stood in the kitchen for a while. The house smelled of coffee and machine oil. Outside, the frost was beginning to lift off the fields. The cornfields ran flat and gray to the tree line. 160 acres of harvested ground that wasn't his anymore by any measure the county would recognize. He'd told no one he was losing it. Not his daughter in Indianapolis, not his brother Dale in Terre Haute, not anyone at the elevator or the co-op. He'd found it easier to say nothing than to explain a chain of decisions that had seemed reasonable when he'd made them. The farmhouse would be listed by the bank within 30 days. He had until January 7th, 2010, to vacate. He went back to the equipment shed and finished replacing the radiator hose. 3 days later, Leland started going through his father's papers. Not for any particular reason at first. The boxes had been in the basement since his father had died in 1998. 11 years on a wooden shelf behind the water heater, untouched. He'd always planned to go through them. There was never a pressing reason. There was one now. The boxes held what old farmhouses tend to accumulate. Tax receipts from the 1960s. A 1974 successful farming almanac with the cover worn off. A folded APA road map of Illinois, creased in the same places so many times the paper had nearly separated. Receipts from a fuel company that hadn't existed since 1981. In the 4th box, inside a manila envelope that had yellowed at the seams, he found the deed. It was 2 pages, typed on onion skin paper, dated April 14th, 1947. Lot 3, Section 9, Township 25 North, Range 10 West, Benton County, Indiana, 160 acres. Purchased by Walter H. Croft from the Midwest Land Holdings Company of Chicago, Illinois. Purchase price, $18,400, paid in full. Leland had assumed the deed was on file with the county. He'd never needed to think about it further than that. He almost didn't read the 2nd page. The 1st page held the legal description and the standard conveyance language. The 2nd held conditions. 12 paragraphs, single-spaced, in the same typewritten font. Most were standard for the era. Easements, drainage and access provisions, mineral rights retained by the selling company for the first 15 years after conveyance. Paragraph 9 was not standard. It read, in language Leland had to parse 3 times with the paper tilted toward the single bare bulb over the water heater, that in the event of any involuntary transfer of title, including but not limited to foreclosure, tax sale, or judicial order, the heirs and assigns of Walter H. Croft retained the right to purchase the property at the most recent Benton County tax assessment value before any third-party transfer could be completed. The right expired after 18 months from the date of involuntary transfer. It ran with the deed itself, not separately recorded. The water heater ticked. A pipe dripped somewhere in the wall behind the shelves. Outside, the temperature had dropped again. The furnace was running. Leland sat on the basement floor for a while. He didn't know what paragraph 9 meant in practical terms. He wasn't a lawyer. He called his daughter first. She told him to get one. Fowler, Indiana, is the county seat of Benton County. Population 2,400. Frank Halsey had been doing land title work there for 31 years. His office was on the second floor of a building on the town square, up a flight of stairs that hadn't been recarpeted since the Reagan years. The hallway smelled of old paper and radiator heat. Leland brought the deed in a paper grocery bag. Halsey read both pages without speaking. He read paragraph 9 twice. Set the deed down on his desk. His desk held stacks of case files organized in a system that was legible to him and no one else. He asked Leland when the foreclosure had finalized. November 4th, Leland said. Halsey asked if the bank had transferred the title to a third party yet. Leland didn't know. Halsey made a call to the Benton County Recorder's office. The call lasted 4 minutes. He asked 2 questions, wrote one thing on a notepad, and hung up. He told Leland the title had been transferred 11 days after the foreclosure, on November 15th, to a company called Prairie Ridge Development, LLC, registered in Indianapolis. Leland had not been notified of the transfer, had not been offered the property at the county assessed value, had not been told that paragraph 9 existed or that his family had any claim under it. The most recent Benton County assessment on the 160 acres and farmhouse, $187,000. Meridian Federal Bank had transferred it to Prairie Ridge Development for $241,000. The difference between what they'd sold it for and the $214,000 debt had covered foreclosure costs, legal fees, and the bank's administrative expenses. Halsey set down his pen. He said paragraph 9 appeared to be a valid covenant running with the land under Indiana property law. He said he needed time to research the case history on preferential purchase rights in foreclosure proceedings. He said it would take 2 weeks. He charged $175 for the consultation. Leland drove home on State Road 28 through flat fields of harvested corn stubble. The sky was low and the color of old sheet metal. He stopped at the grain elevator in Oxford and bought a coffee from the machine in the break room. 2 farmers he'd known for 20 years were discussing spring soybean contracts by the scale house. He didn't mention the deed. 2 weeks felt like a long time. Halsey called on a Thursday morning in the first week of December. He said he'd found 3 relevant Indiana cases, one from 1961, one from 1978, one from 1994. All 3 supported the enforceability of preferential purchase rights in deed covenants when 3 requirements were met. The covenant had to be in writing, it had to run with the land rather than with a specific individual, and the original parties had to have been legally competent at the time of conveyance. The Midwest Land Holdings Company of Chicago had been a legally registered Illinois corporation in April of 1947. Walter H. Croft had been a competent adult. The deed had been properly filed with Benton County the same month it was signed. All 3 requirements met. Meridian Federal Bank had transferred the title to Prairie Ridge Development without first offering the property to Leland at the county assessed value. That was a violation of the covenant. The transfer to Prairie Ridge Development was potentially voidable. Halsey used the word potentially carefully. He said Leland had two options: file suit to void the transfer and exercise the purchase right at assessed value, or contact the bank directly with documentation and see if they'd negotiate without litigation. Litigation, 18 to 24 months. Cost, $8,000 to $14,000 in legal fees. The negotiation route was faster if the bank moved. Banks rarely moved fast, but they sometimes moved faster when the alternative was litigation that would cloud a title on a property they were trying to sell. Prairie Ridge Development had filed a rezoning application with Benton County on November 28th. They intended to convert the property into a 34-lot rural residential subdivision, Prairie Ridge Estates. The rezoning hearing was set for March. A clouded title would stop that hearing entirely. Halsey drafted a letter to Meridian Federal Bank's legal department on December 8th. 4 pages. Attached to it was a certified copy of the 1947 deed, both pages. The letter laid out paragraph 9, cited the 3 Indiana precedent cases by name and year, and stated that Leland Croft, as the surviving heir of Walter H. Croft in the direct chain of title, had not been offered the property at assessed value prior to transfer. The letter requested the bank acknowledge the covenant, void the transfer to Prairie Ridge Development, and extend Leland the right to purchase at the Benton County assessed value of $187,000. 30 days to respond. The response came on day 21. Meridian Federal Bank's legal counsel wrote back. The letter acknowledged receipt of Halsey's correspondence and the attached documentation. It did not acknowledge the covenant. It stated that the bank believed the November 15th title transfer had been conducted in full compliance with Indiana foreclosure law, and that no additional obligations to prior owners existed under the terms of the mortgage or any recorded instrument. Halsey had expected this. He filed in Benton County Circuit Court on January 14, 2010. The complaint sought to void the transfer to Prairie Ridge Development and enforce Leland's preferential purchase right under the 1947 deed covenant. Leland paid the $3,500 retainer from the proceeds of equipment sold in November, the 4230 tractor, a tandem disc he'd used for 14 years, and a grain auger his father had bought in 1979. Prairie Ridge Development hired a 4-attorney firm out of Indianapolis. Their first response argued the covenant was unenforceable because it had not been separately recorded and had not appeared in any title search conducted by Meridian Federal Bank or Prairie Ridge Development prior to the foreclosure or the transfer. Halsey countered that Indiana law placed no requirement on a covenant running with the land to be separately recorded. It was part of the original deed. The original deed had been recorded with Benton County in April of 1947. It had been sitting there for 62 years. Any title search that examined the chain of title would have found it. The question was whether anyone had looked. The judge in Benton County Circuit Court was a woman named Elaine Forsyth. She had been on the bench for 9 years. She scheduled the hearing for February 19th. It lasted 3 hours. Prairie Ridge Development's attorney argued that enforcing a covenant from 1947 would create uncertainty in Indiana property transactions and punish a buyer who had acted in good faith, relying on standard title search procedures. He cited 3 cases. Halsey distinguished all 3, noting that in each, the covenant in question had been created after the original deed, not as part of it, and had not been attached to the recorded instrument. Forsyth asked one question from the bench. She asked whether Prairie Ridge Development's title insurance policy would cover a defect arising from a deed covenant that had been present in the recorded chain of title since 1947. Prairie Ridge Development's attorney said he believed it would. Forsyth said that answered several of her concerns. The ruling came March 3, 2010. Elaine Forsyth found in Leland's favor. The preferential purchase right in paragraph 9 of the 1947 deed was a valid covenant running with the land. Meridian Federal Bank had transferred title to Prairie Ridge Development without notifying the Croft heirs or offering them the right to purchase at assessed value. The transfer was void. Leland had 60 days to secure financing at the assessed value of $187,000. Prairie Ridge Development appealed to the Indiana Court of Appeals on March 19th. The appeal cited 4 grounds, including the argument that enforcing the covenant was an unconstitutional impairment of the existing purchase contract between the bank and the development company. The Court of Appeals denied the appeal on July 11, 2010. 4 pages. It found no reversible error in the trial court's analysis of the covenant's enforceability. Prairie Ridge Development did not appeal to the Indiana Supreme Court. Leland had used those 4 months to arrange financing. The USDA Farm Service Agency ran a direct loan program for farmers in financial hardship. He applied in March. Spent the following 16 weeks assembling documentation. 7 years of tax returns, crop yield records, a soil productivity report from the Purdue Extension Office in West Lafayette, and a letter from Frank Halsey summarizing the court ruling and its legal implications. The FSA approved the loan on August 4, 2010. $187,000 at 3.75% interest. 30-year term. Monthly payment, $869. He closed on the property in Fowler on August 19th. The paperwork was signed at a folding table in the Benton County Recorder's office at 2:15 in the afternoon. Halsey was there. The deputy recorder was there. No one from Meridian Federal Bank attended. The total cost of the legal fight, $7,200 in attorney fees, $340 in filing costs, $80 in certified copy fees for the deed. He'd taken the 160 acres back for $187,000 at assessed value, $54,000 less than the bank had collected from Prairie Ridge Development. The development company's title insurance carrier settled their losses quietly. The amount was not disclosed publicly. The farmhouse had sat vacant for 9 months. The bank had winterized the plumbing but kept the heat no higher than 45 degrees. The limestone foundation was fine. The windows had fogged on the inside from cold air meeting warmer air through the glass. A family of raccoons had taken up residence in the attic through a gap at the soffit Leland had been meaning to seal since 2007. He sealed it in September of 2010. His daughter came up from Indianapolis that fall. She brought a dark wood frame she'd bought at a hardware store in Lafayette, wide enough for both pages of the deed. She mounted them side by side behind the glass, paragraph 9 visible near the bottom of the right page, and hung the frame in the front hallway between a Benton County Farm Bureau calendar and a photograph of Walt Croft standing next to a 1949 Farmall M tractor. Walt had been 31 years old in that photograph. Leland was 60 when he moved back into the farmhouse. He planted soybeans in the spring of 2011. 140 acres, kept 20 acres in hay ground for a small cow-calf operation. He started with 9 head of Black Angus purchased at a farm dispersal sale in Newton County. The cows used the equipment shed he'd cleaned out that winter. He found the rag on the floor by the workbench, the one he'd wiped his hands on the morning the bank took the farm. Still there, still grease-stained, right where he'd dropped it. He threw it out. Halsey wrote a summary of the ruling for the Indiana State Bar Association's Agricultural Law newsletter in the fall of 2010. 4 paragraphs. It referenced the 1947 deed, the 3 precedent cases, and the legal standing of preferential purchase rights in foreclosure proceedings. It did not name Leland. 4 other farmers contacted Halsey's office over the following 2 years. each of them with old deeds they wanted examined for similar language. 2 of the deeds contained enforceable covenants. 1 case settled before it reached trial. 1 was still pending when Halsey retired in 2017. Meridian Federal Bank was acquired by a regional holding company in 2013. The Fowler branch closed in 2015. Leland farmed the land until 2021. 12 years from the morning the 2 men in the dark blue Buick had turned down the gravel drive and taken a photograph of the house. He sold to his nephew in the spring of that year. Same 160 acres, same 2-story farmhouse, same limestone foundation. He kept 2 things when he sold: the 1947 deed in its dark wood frame, and a letter from the Benton County Recorder's Office confirming the August 2010 title transfer. Meridian Federal Bank's hold on the property released. His name back on the document. His nephew farms the same ground today: corn and soybeans. He knows the story of the deed, has heard it once from Leland, all of it, from November 2009 to the afternoon at the folding table in Fowler. He has not read the deed himself, has not needed to, knows it's there, knows what paragraph 9 says. That is enough. Walt Croft bought 160 acres of Benton County ground in April of 1947 and put his name on a deed. He put conditions on that deed, or the Chicago Land Company did. Someone who wanted to ensure the land would be treated fairly if it ever changed hands against the owner's wishes. Either way, the language existed, filed with the county in April of 1947, sitting in the record. For 62 years, nobody looked at it. For 62 years, it didn't matter. In November of 2009, it did.